Welcome once again to Lehto's Law. Here's Steve Lehto.
Mike pointed out an interesting situation in North Carolina where local prosecutors won't reveal which officers are too untrustworthy to testify. The News and Observer published a story, and it's written by the NC Watchdog Reporting Network. Locked away in prosecutors' offices across North Carolina sit documents declaring certain law enforcement officers in their jurisdiction too untrustworthy to testify in court. So the prosecutors have actually identified different officers, and they said, this officer here, we can't call him as a witness. He's not trustworthy. Now, prosecutors often keep track of these things when they become aware of information about a police officer or a sheriff's deputy that would call into question their credibility on the stand. When a district attorney decides that an officer is not credible, the officer is likely also to no longer ever be called as a witness in court. Being functionally unable to testify in court means they really can't make arrests or be involved in handling evidence. So what can they do? Well, sometimes officers refer to these as death letters because they kill their careers. But in North Carolina, those letters are rarely seen by anyone else. There's also no formal system for tracking or reporting these letters or the untrustworthy officers that they're writing about. So that could change because they proposed some new laws there. The House and Senate each passed bills in North Carolina that would require centralized reporting of these letters, creating a database that law enforcement agencies could consult when hiring new officers. The legislation would also give officers a process for challenging complaints made against them, but the documents would still be off limits to the public. So if you're in North Carolina, it's possible there's a police officer in your jurisdiction who's been deemed so untrustworthy and unreliable that he won't get called as a witness in any cases. And yet, out patrolling, doing the police business. And again, what happens if that police officer becomes a witness or is necessary to testify? So, prosecutors, relying on guidance from the North Carolina Administrative Office of the Courts, refused to produce any of these letters when a North Carolina Watchdog Reporting Network requested copies of the letters written by the various district attorneys over the past 5 years. It was just a blanket denial. We're not going to give them to you. They claimed there was an exemption in the state open records law for criminal investigation records. Most also refused to answer basic questions, including how many such letters their office had issued in the past 5 years. Now, what happened was, in 1972, the U.S. Supreme Court sided with the criminal defendant and granted him a new trial because the prosecution did not turn over key evidence about a witness's credibility. Now, all evidence that could feasibly be used to impeach a government witness is constitutionally required to be turned over to the defense. So if you're involved in a case and one of these police officers is going to testify, then theoretically the prosecution will let you know, by the way, there's a problem with this one officer's testimony. This gave birth to these letters, which were warnings from a judge or most often a district attorney to a law enforcement agency that a certain officer is not a reliable witness and shouldn't be called to the stand. These are also sometimes referred to as Brady lists after a similar precedent-setting court case. Several other states, like South Carolina and Florida, make them public. Federal prosecutors also issue the letters, including against North Carolina officers. Lawmakers say there's only been a handful of these letters in recent years. There's never been an accurate public estimate of just how often law enforcement officers are considered too unreliable to put on the stand. The effort from the reporting network sought to bring some light to the subject. As requests streamed in from reporters, emails show that officials at the North Carolina Administrative Office of the Courts contacted elected district attorneys with guidance on how to respond. So they said, here's what you should do. Now, the agency's understanding was that the only reason DAs have these letters and lists is to fulfill the state's obligation to disclose to the defense any details that might cast doubt on an officer's testimony against the accused. So they sent out more instructions to prosecutors to tell them about 2 webinars they were hosting to coach them on how to respond to requests for the story. So they're basically being said, told, here's what you do, but don't give up the information. As a result of this coaching, nearly every response from a district attorney for this story was the same. These letters are investigative in nature and cannot be released. Now, there's no law or regulation requiring district attorneys who are independently elected constitutional officers to follow the advice of the administrative office of the courts. So the DAs could turn this stuff over if they wanted to, but nearly all responded to the reporting network's request for the story. 10 of the prosecutors said their office did not have any responsive records or weren't aware of any such letters. Nearly all cited a version of the guidance offered by the administrator's office, and the rest didn't respond. Only one district attorney, and there's 42 in the state, only one answered a question about how many of the letters his office had issued since 2016, and he said he had letters on file. He says, "We have reviewed our files, and I believe I've sent 3 letters since 2016, and they were to 3 different agencies. None of these were the so-called death letters, but were notification that the info I had received would require notification to the defense in any case that would require the individual officer to testify in a criminal prosecution. Several prosecutors simply directed those questions to the administrative office of the courts. Spokesperson for the AOC declined repeated requests for an interview on the agency's insistence that these letters are not public record." A Raleigh attorney who frequently represents the media and public records litigation said the advice given by the court system lawyers and parroted by district attorneys doesn't square with state public records law. They don't fit the record of violations of law or criminal intelligence information as defined in the statute. And if they're not specifically statutorily exempt, then they're public. That's about the crux of it. Said he also takes issue with the administrative office of the court's role in the effort to release the records or not release the records. "I understand the AOC's desire to have consistency, but the consistency needs to comport with the law. I find it disappointing there's almost a gatekeeper function being imposed on public records by the administrator when it comes to district attorneys in North Carolina." So, like I said, there's legislation that's been put forward to make these things public in North Carolina. But this is also going to be one of those things that varies wildly from state to state. And that often happens where stuff happens in one state but not another. Laws are different. Customs can be different. And, it takes time. But the real issue here is that there's police officers all across this nation. I've talked before about the several different jurisdictions in almost every state. You've got the local police, the county sheriffs, the state troopers, or whatever you call them. But there's 3 different jurisdictions. And so if something happens where the prosecutors realize this one police officer here, if they ever get on the stand, they're going to be destroyed on their credibility because of something that they have in their past. Okay? So they send a letter to the department that says that officer really can't take the stand. And if they do, it's going to get ugly. So do what you can to keep that officer away from anything that's going to wind up in court, which for police is difficult to do, I would assume, because a lot of what they touch ends up in court. So the fact that these letters exist seems like that would be of public interest, And now they do give the information up if that police officer does take the stand. But if that officer never takes the stand and they're not required to turn the letters over to anybody else, then they sit in a filing cabinet somewhere and only 3 or 4 people know about it. And I would assume that that would be something that people would like to know about. If there's a police force in your community and there's a police officer employed there who's been deemed so untrustworthy that they've been told to avoid legal situations because you can't testify. You've got problems with your credibility. And so I think that's something that the public should know about. So it's good that they're going to pass a law to kind of make this more public, but then it says that some of it's not going to be fully open to the public. So it's strange. But it's something I think that as more people find out about and know about, that, it's like civil asset forfeiture. When I started making videos 7 years ago, the first reaction and response I got to civil asset forfeiture was, what? No, that can't be real. That does not exist. And then that turned into, whoa, really? That exists? To where we are now, where people are upset and outraged by it. And now we actually have states that are abolishing civil asset forfeiture. So I think as more and more people become aware of something like this, it's more likely that something good will happen in this field. So a situation being illustrated in North Carolina is that local prosecutors there won't reveal which officers are too untrustworthy to testify. There are documents that identify those officers, but they are not available to the public. So the News and Observer published it, newsobserver.com. Mike sent it to me. Thanks a lot. Questions or comments? Put them below. Otherwise, I'll talk to you later. Bye-bye.
Thank you for watching Lehto's Law. A mama bear is not more afraid of you than you are of her. Memorize this. It's important.